It's really important that property owners maintain their property for their tenants and guests in a safe manner. Too often, absentee landlords profit off of their tenants without really doing the upkeep and to keep these places safe. I've had a number of cases like this, and I've also had cases where decks or porches collapse. I wanted to visit with you about one right now. I represented Mary and Michael Macharia, former clients, current friends, in a deck collapse. On Memorial Day in 2013, their deck collapsed. This was featured in an article in the lawyer's newspaper, the Missouri Lawyers Weekly. We did extensive litigation. We're able to obtain a $1.4 million settlement for Michael and Mary to take care of them and their injuries. Their medical damages together were about $110,000, and we certainly got a great recovery for them. Very interesting case. After the deck collapse, the building management, who had made hundreds of repairs, the condo association and the management company, who had made hundreds of repairs to these decks over the years, sent out a memo the day after saying, it's not our responsibility, it's the unit, the homeowner's responsibility. And our clients were renting the condo or apartment from someone else. Sandalwood Creek Condominium Association and Roy Smith Management Company put out these memos, talked to the local press, and gave out this false story. When I deposed the manager of Roy Smith, she admitted that the memo that they had put out, the press release they had put out the next day, contained 3 lies in it. They had done that to these people, and we had to litigate it and fight them for a long time before we were able to win this case and get the decisive victory that we did. Not only that, but Mary Macharia had complained to the owner about this porch for about 3 months prior to this collapse, and she said it was wobbly. We need to do something about it, and he kept saying he'd come out, but never did. And what happened was the porch separated from the wall of the apartment and then collapsed down. It wasn't bolted in. The day after this incident, St. Louis County came out and put 60 of these porches, these decks, out of code because they weren't bolted to the walls. So if you have a deck, go check your deck and make sure it's not just nailed in, it's bolted in, because what happens is this, with the swelling and the shrinking of wood through the seasons and with moisture, it'll pull these nails out of the wall. They should be bolted into the side. And these folks knew that. That is the current code now. It wasn't the code 30 years ago when these were built. And despite their denials about the safety of these decks that we kept trying to say to them, they kept saying no. And we said, well, listen, we have all these repair orders, and you guys were replacing these decks and rotted wood, and these nails not working. The president of the condominium association, who owned 50 units there and made a lot of money off these things, said that they were, I quoted it in here, that they were in incredibly bad shape, and they knew it. So this management company, there was no responsibility taken. Everybody's denying responsibility. The condo association, who had the rules that were supposed to enforce it and supposed to repair these common areas, blamed the owner. The owner blamed the condo association, and both of them blamed the management company. And the management company said, we were never told to replace these things, but they went on these regular inspections and did it. I could go on and on, as you can tell, about the facts and circumstances of this case. But it's important to note that our clients were the innocent folks who got injured from this. We had clear ordinance and rule violations by the owner, who didn't keep up his property, by the condo association that did not administer the rules of the condo association, did not remedy the decks, and did not remedy the common areas. And the management company, that was a professional management company, they're the folks whose job it was to know this stuff and to repair it, and they never did. After extensive litigation and depositions, we had a large mediation. We were able to settle this case for $1,435,000. We obtained money from all of the defendants and were able to set up a structured settlement and to help Mary and Macharia in the future, as well as current money to help them now. We got them a house. They bought a great new house. And so we're very happy and proud to represent them and help them. If you have any questions about debt cases, about standards and rules about those, about multiple parties and divisive and failure to take responsibility, please call me 314-542-2222, Gary Berger, or visit us at bergerlaw.com. Thank you.